you wrote and published an article about child sex abuse cases and the standard of care and how to cut through those things. So a lot of times we're handling cases as lawyers where the perpetrator is uninsured. They don't have the money to compensate the victim for the harms done. So can you kind of walk our listeners through what they have to do and prove to kind of be able to compensate our clients for whenever they're sexually abused?
For sure. It depends on the organization. If you're suing school districts or universities that are publicly owned, a lot of times you'll find that there are rules and regulations, the mandatory duty to supervise, for example, of an elementary school children. So you want to make sure you understand that there's certain laws that apply to public entities versus non-public entities. And with any negligence case in California, you need to prove notice for a non-public entity. I mean, you also need notice in some sense when you're suing school districts for sex abuse or bullying or assault, what have you. But in terms of notice, it's not that hard because there's usually red flags. And there's red flags of inappropriate conduct. And you have to show that there was a tendency of this person to behave inappropriately. You don't have to necessarily show that there was the exact same sexual assault that had occurred previously in these cases.